Hello, I'm Dr. Rahul Khare. Thanks for taking the time to look at this module on how to effectively review medical records. We'll cover the following topics in this module. First, understanding negligence and what is required for a claim to have merit. Second, how to conduct a medical legal review, including a few hints on how to meet attorneys' expectations of an expert review. And lastly, how to effectively communicate your findings upon completion of the review. So let's get started with what makes a viable case. Simply put, negligence is the commission of a medical error that is the proximate cause of some harm to a patient. In order to have negligent claim, the claim has to have merit. The patient must be under the care of a healthcare provider in question. This is referred to as duty of care. Once the duty is established, then it must be established that the provider in question must have deviated from the standard of care. And the deviation from the standard of care must be the direct and or proximate cause of a bad outcome, or what are known as damages. In other words, if not for the deviation from the standard of care, the patient's bad outcome or damages would more than likely not have occurred. So in order for a case to have merit, all of these elements must be present. The provider must have deviated from the standard of care, and the deviation must, more likely than not, have caused the damages. These elements are sometimes referred to as liability, causation, and damages. Different specialists are often required to opine on each of these areas as they relate to the specialist's area of expertise. For example, suppose an ER doctor committed an error in treating a patient which led to the patient developing an infection and causing that patient to remain hospitalized for an extended period, thereby missing months of work and incurring significant medical bills. In this example, the ER expert would be required to opine on liability, while an infectious disease expert would likely be required to opine on causation. This case might further require an economist or billing expert to opine on the value of the damages. A final thought on these essential elements. In reviewing records, it's not always necessary to start with liability. Since all three elements are required for a case to be meritorious, you only need to determine if one is missing, and if so, there's not a viable case. So let's move on to the nitty-gritty of the module and talk about reviewing medical records. Before even beginning to pore through records, it's helpful to have some basic information. What's the case about, and what is the attorney focused on? Are there specific questions or areas of concern you've been asked to address? Have you been asked to focus on only one of three essential elements? Has a summary, chronology, or cover letter been provided? These are very important questions to have answered before you start. Sometimes there may be little to no additional information beyond the stack of records, which can often be extremely large and disorganized. It's important to get an overview of what went on first, so you must scan through the records so you can understand what happened. Many pages in the medical records are purely clerical, and some are repetitive. It's not necessary to read every single page on your first pass. It's also okay to jot some notes down during a review and page numbers of importance. I like to take notes of dates and times of critical events and providers involved. After a first read-through, think about what you've been asked to address and go back to those critical events if need be, get a thorough understanding of what was done and what may have been missed. Remember, negligence is rarely well documented, so you're often looking for what was missed or not done as much as what was done. It's important to conduct a thorough review so that you can be prepared for a meaningful discussion with the lawyer. Attorneys will want to understand why this is or is not meritorious case, so they can prepare and have a discussion with their client. But do your best and be mindful of the time spent and the cost. Your time is valuable, and you should be compensated fairly for it. But remember, this is a significant expense to attorneys and their clients, simply to determine if they have a case or not. Prior to your discussion with the attorney, be sure to know the case, particularly with respect to your specialty area. Be prepared to describe what happened and what the standards of care are with respect to the case. I like to start the discussion by giving the lawyer a brief overview of what happened and then ask if there was anything important that I omitted from the summary. I then describe why this is or is not a meritorious claim, in my opinion, and answer any additional questions that the lawyer has. Obviously, it should be an open discussion. Honesty is always best. The attorney may disagree, but remember, you are the expert. You must be ultimately comfortable with the opinions you deliver, as you may be required to stand behind them in writing and possibly in court. As always, feel free to contact us with any questions or comments, and thank you for taking the time to view this presentation.